Okay, everybody, please return to your seats, and we will start now with the fourth panel. We will also this last round, we will start with a presentation, and then we will move on to the fourth panel, which will look into more domestic legislation and the Norwegian situation, so to say, and then the question whether Magnitsky-like sanctions should be adopted in Norway, or how we can, and so if that is a good means to protect human rights defenders in Norway. But since we now are moving into a more domestic landscape, we had the pleasure of having a representative from the US Embassy here, Mr. Eric Carlson, who will start this session by giving a presentation on the US Magnitsky Act. So that will be a good basis for discussion on the Norwegian issues. So, Mr. Carlson, please provide us with some insight on the US legislation, please. Thank you.
Thank you. Good afternoon, members of the diplomatic community, friends from civil society and the Norwegian government, ladies and gentlemen. On this rather chilly winter day, I would like to extend my very warmest greetings from the Embassy of the United States here in Oslo, as well as the Chargé d'Affaires at the Embassy, James DeHart. It is wonderful to be here this afternoon to support such a worthwhile initiative and to join a very distinguished group of speakers. The United States government and the Department of State is very proud of the role that we play in promoting human rights. The advancement of human rights has been a central element of U.S. foreign policy for decades. We have long sought to achieve several important goals in this field, including holding governments accountable to their obligations under universal human rights norms and international human rights instruments, such as the UN Universal Declaration on Human Rights. Promoting greater respect for human rights worldwide, including freedom of expression, press freedom, women's rights, and the protection of minority groups, and strengthening the rule of law and helping change cultures of impunity. These tenets are exemplified by the Sergei Magnitsky Rule of Law Accountability Act, also known as the Russia Magnitsky Act, which was passed by the U.S. Congress and signed into law by President Obama in December 2012. I was asked to share some information with you today about how the Act works, even though I know some of you are very familiar with it, and to touch on where we go from here. To start, the Russia Magnitsky Act does two things. First, it provides for the designation for sanctions of persons determined to have been involved in the criminal conspiracy uncovered by Russian lawyer and whistleblower Sergei Magnitsky, as well as those individuals determined to be responsible for his detention, abuse, and death, those who profited from his detention, abuse, and death, and those who helped cover up the legal liability for his detention, abuse, and death. Second, the Act provides for the designation of persons responsible for gross violations of internationally recognized human rights in the Russian Federation against individuals who are seeking to expose illegal activity by Russian officials, or alternatively, against individuals seeking to exercise, obtain, defend, or promote their internationally recognized human rights. So, what happens when individuals are designated for sanctions under this act? To start, they are ineligible for U.S. visas and ineligible for admission into the United States. No business meetings in New York, no vacations in Miami. These individuals are also added to this is a rather long term, the Treasury Department Office of Foreign Assets Control's list of specially designated nationals and blocked persons. That's quite a mouthful, so it's also referred to as the SDN list, which freezes any financial assets they may have in the United States. In addition, U.S. persons are generally prohibited from engaging in transactions with them. Now, efforts to implement the Act have so far resulted in a list of 35 individuals who were involved in various aspects of the Magnitsky case, as well as 9 others responsible for gross human rights violations in the Russian Federation unrelated to Magnitsky's mistreatment. Their inclusion in this list promotes accountability for their actions. Their inclusion in this list also sends a powerful signal to human rights defenders across the world. Many of the listed persons were involved in some of the most serious human rights abuses in recent Russian history, including the extrajudicial killings of, and please pardon my pronunciation of some of these names if I get them wrong, journalist Paul Klebnikov, whistleblower Umar Israilov, and whistleblower Alexander Litvinenko. Now that you know what happens when an individual is sanctioned under the list of the Russia Magnitsky Act, you may ask, how is the list actually created? And there was some discussion just recently about this list and how is it determined. The Department of State very closely examines any available information that indicates an individual may meet the established criteria. The State Department considers information from a broad array of sources, in addition to conducting its own specific research. Placing a person on this list is a serious undertaking. It's not taken lightly, and it requires a conclusive demonstration or determination that a person meets one or more of the criteria for inclusion, and that determination must be supported by credible information. We welcome information from human rights monitors and other credible sources about persons who might meet the law's criteria, and we do fully consider this information. In some cases, information provided by human rights NGOs has successfully resulted in designations. In other cases, the conduct of suggested candidates for the list has not met the criteria in the Magnitsky Act, particularly the very high bar of being responsible for a gross violation of human rights. The United States encourages human rights organizations to continue to provide us with information about individuals who may meet the Act's criteria. For those of you interested in such efforts, please keep in mind that there are a number of strict requirements that must be independently and extensively demonstrated in any Russia Magnitsky dossier that you may provide. Among these are that the person's conduct was a gross violation of human rights and is well documented. Gross violations of human rights may include, but are not limited to, extrajudicial killings, torture, and enforced disappearances. Also, the victim of the gross violation of human rights must be a whistleblower or a person seeking to exercise, obtain, defend, or promote internationally recognized human rights in Russia. The Department of State is committed to continued robust implementation of the Russia Magnitsky Act, and work on the Russia Magnitsky Act is active and ongoing. I hope that I've been able to demystify just a little bit of the elements of the 2012 Russia Magnitsky Act, and now I'd like to share a few words on what is known as the Global Magnitsky Human Rights Accountability Act, which was enacted by the US Congress and signed by the President on December 23, 2016. Similar to the original law, this new global act authorizes the President to impose financial sanctions and visa restrictions on foreign persons in response to certain human rights violations and acts of corruption. With the passage of the Global Act, the United States now has a specific legal authority to identify and hold accountable persons from any country responsible for gross violations of human rights and acts of significant corruption. The global reach of this authority, as opposed to authorities previously confined to the United States in the original legislation, combined with a very judicious selection of individuals and entities, will send a powerful signal that the United States continues to seek an end to impunity with respect to human rights violations and corruption. The Trump administration is committed to implementing the Global Magnitsky Act and is actively seeking to identify any persons to whom this act may apply. But again, the bar is high, and these are taken very seriously in terms of creating designations. By complementing current sanctions programs around the world and diplomatic outreach, the Global Act creates an additional authority to allow the administration to respond to crises worldwide and pursue accountability, including where country-specific sanctions programs may not exist. With the establishment of the first, but certainly not the only, dedicated global human rights and corruption sanctions program, the United States is uniquely positioned to lead the international community in pursuing accountability abroad consistent with our shared Western values. the United States is committed to encouraging other countries to impose sanctions that are similar to those provided for the Global Act. The Department of State actively participates in global outreach, including the G20 Denial of Entry Experts Network, which is a subgroup of the G20 Anti-Corruption Working Group, in which countries share best practices among visa and immigration experts. Through this network, the United States has encouraged other G20 members to establish and strengthen corruption-related visa sanctions regimes. We note that the United Kingdom recently enacted legislation similar to our Global Act, and we will be consulting very closely with the UK government as we implement our respective laws. The Department of State has ongoing bilateral human rights discussions with other key allies, such as Norway, and will be raising the possibility of their imposing sanctions similar to those authorized by our Global Magnitsky Act. We have also been meeting with the NGO community and civil society organizations to discuss efforts to implement the Act, as well as to answer questions from the NGO community. As with the Russia Magnitsky Act, we welcome and appreciate information from and engagement with non-governmental organizations. Evidence permitting, our hope is to leverage the global reach of the authority provided under the Global Magnitsky Act and pursue geographically diverse targets for both the financial sanctions and visa bans on an ongoing basis. So in closing, I would like to highlight the great work of the Norwegian Helsinki Committee in promoting human rights, both here in Norway and throughout the world. It's a great organization. And once again, thank you for the opportunity to speak with you here today.
Thank you very much, Eric Carlson. I forgot to say that Eric Carlson is the Counsellor for Political and Economic Affairs at the US Embassy here in Oslo, and was kind enough to give us some insight in the US legislation, and there was also an encouragement there, I think, to develop Magnitsky-like sanction legislation in Norway too, and that is the issue of the last panel. So we are now rearranging the scene a little bit, and we will get some Norwegian participants on the scene. So as soon as you get some chairs, you will be able to establish. We will be able to establish a panel. Gro will lead this last panel, and that will be followed also with some concluding remarks, which will end this session before then a light meal and a theater. So please, will the panel number 4 come to the stage, and we will place you there. So, and then I leave the floor to Gro, who will then lead this panel discussion. So please.
Thank you very much, Frode, and thank you all for still being with us for this last panel, where we are going to narrowing the scope slightly by focusing on to which extent we will be able to have Magnitsky sanctions in Norway. We have an overarching, 2 overarching questions for this panel, and what I would ask the panelists to do is to address the 2 questions that we have, which is how can Norway strengthen protection of human rights defenders and whistleblowers, and how could Norwegian Magnitsky legislation look like? We have a very good panel here. What all have in common, I think, is they are human rights experts, but representing very different approaches and roles in this panel. And I think we will. I will ask the panelists to start by introducing themselves slightly, a little bit more, and to see, what's their take into these 2 questions. But also that you are relatively free to address the issues that you've heard during the day today. And I think we start with from the left to the right. So we start with Petter Eide. Let me just quickly, it's Petter Eide. He's the only MP on the panel representing the Socialist Left Party. And then we continue after that with Bjørn Engesland, whom you all know, who is the Secretary General for the Norwegian Helsinki Committee. Then we have Bård Larsen from Civita. And then we have Nora Sveås, who is Associate Professor from the University of Oslo, and also member of the UN Subcommittee on Prevention of Torture. And finally, we have Beate Ekelöv-Slydal. She's political advisor for Amnesty International. So please, Petter Eide, the floor is yours.
Yes, thank you very much, Gro. It's a pleasure to be here. And Bjørn, congratulations with your 40 years anniversary. Tomorrow I will champagne with you, but today I will just say congratulations. I'm representing the Socialist Left Party. I'm not representing the whole parliament, just to say that. I'm representing the left side. That's why I'm actually on the right side here. I should be over there. Same. Okay, anyway, my Socialist Left Party are, of course, very positive, using sanctions as international instrument to fight human rights violation. Let's just be very clear on that. That's why we were positive to also to sanction Russia after the Crimea affair. We have for many years called for sanction of Israel due to the occupation of Palestine. We have been positive to the previous sanctions of Myanmar, and of course back in the 90s the sanctions of South Africa, just to list it up. So we are actually positive using sanctions. And nowadays we are also calling for weapon embargoes, which is a kind of sanctions as well to countries in the Arabic region, as an instrument to prevent the warfare in Yemen. So far so good. But coming into this particular issue, I have some questions, challenges, considerations I would like to raise for you. I think which links directly into the Norwegian debate. Sanctions in nature must be international. Those countries that should be a part of sanctions should be part of an international agreement or international framework. So a little bit provocative, I would say that by calling this a Magnitsky process and calling it the Magnitsky Act totally prevents Russia to be a part of this. Russia will look at this. I mean, if Norway or other countries introduce a Magnitsky Act, they will look at this as another attack on them, and they will not necessarily look at this as a kind of a human rights tool. So my first advice for those of you who champion this work was to rename the whole process. Stop calling it the Magnitsky Act or the Magnitsky process. Find a kind of a neutral label that can include as much as possible, as many countries as possible. Secondly, I think we need to discuss whether it's wise to transform a sanction process into a legislation. In nature, sanction must be temporary, not permanent. By making them an act or legislation, it looks like more temporary thing. It looks like more permanent thing, and it makes it also difficult to change them, to adjust them into a new situation. So I'm a little bit critical or a little bit hesitant to support the process where we are taking sanctions, transforming them into acts. And secondly, I think doing so, we unnecessarily politicize the sanctions into the parliament, and we run the risk that politicians from all kinds of politicians are using sanctions on human rights for other purposes. They're using it for other purposes than fighting human rights. We must not be naive when we are discussing the Magnitsky Act in US. US they have not introduced this to be champion on human rights. They are doing this because it falls into a large overall agenda towards Russia. And it will be, the notion from Russia will also be like that. And by doing this, and even by calling it the Magnitsky Act in US, they are in a way constructing a new kind of conflict and a new kind of tension, and they're even making it kind of permanent by making it into an act. So I'm a little bit critical for bringing this into an act, into legislation, because that might make it a little bit more permanent, less flexible, and also politicizing it, and in a way taken it away from the human rights sphere and into the more political sphere, which I think is not very wise. My third point, if I have more time, my third point is that this kind of framework for sanctions should not only be an instrument for strong countries. I mean, we must be aware of that. Who will run sanctions on US? Who will run sanctions on Israel, on China? So by making this kind of framework, we run the risk that this will also be another way of power play between the strong and big nations. And we need to avoid that. So that's why I'm a little bit hesitant for the way the Magnitsky process has been set up and the discussion around it. I think just both the name and the content on the legislation in US, and also a little bit about the discussion in Norway, it looks like a particular attack on Russia. It's not a new instrument for human rights. It's looks like, and definitely from Russia, a new attack on Russia. I think the most important thing now, I came just from Brussels. I've been in the meeting in the Parliament Assembly in the Council of Europe. One big problem there is that the Russians are not included. They were excluded after the Crimea affair. It creates a big problem. Yesterday we discussed violence against women and legislation for violence against women. The Russians were not there. We could not have an opportunity to discuss this with them and the situation in Russia on this. We need to kind of see a balance between carrot and stick in this. And we need to bring the Russians on board in the human rights dialogue. We need to find a way to include them in the human rights dialogue. And we do not do that by making a new instrument called the Magnitsky process or Magnitsky Act. Thank you.
Thank you. I think you raised some very important questions and limitations, which is very tempting to start opening a debate about right away. But I think we should rather go through the whole panel with 5 minutes each, and then we can get back to a discussion on some of this. So please, Björn, the floor is yours.
Thank you very much. I guess the very basis for our involvement as the Helsinki Committee in this issue, and to bring up the question of Magnitsky and Magnitsky-like sanctions, is the realization that the situation for human rights activists, human rights defenders in many countries are getting increasingly difficult. We don't think that we have the necessary instruments, the necessary ways to deal with that situation, to give them the necessary protection, and to deal with those people that violate their rights. That's what we try to do something with. Let me just say that in many ways, we as an Helsinki Committee experience, and I probably said this many times, that we are facing some of the same challenges today that we did when we were established 40 years ago. And that is to try to support brave human rights people in Europe, in the former Soviet Union. In my opening speech today, I described the exhibition that we opened this week, where we tried to highlight how at least 14 brave activists have acted during this period of time in order to defend human rights, many of them paying the highest price for what they were doing. We have engaged ourselves in trying to get into a dialogue with political representatives in Norway, with parliamentarians, with the Ministry of Foreign Affairs. We have been doing this for several years. We have had many seminars, taken many initiatives, invited people from abroad to come here in order to discuss. What we are doing today is part of this process. We have proposed that Norway, coordinated with and or in cooperation with other democratic states, establish Magnitsky sanctions. We strongly believe that if Norway and other democratic states in Europe and democratic states in other parts of the world establish global Magnitsky sanctions, this would have a substantial impact on the strengthening of the respect for human rights worldwide. We think that democratic states in Europe and elsewhere should come together and discuss how they could cooperate on such measures. We see the campaign for Magnitsky sanctions as supplementary to the efforts that Norway and other human rights friendly countries do within the framework of the UN and other international organizations. We do not accept that there is an either-or between dialogue and Magnitsky sanctions. Magnitsky sanctions are targeted against officials and the partners who commit very serious human rights violations or extensive corruption. It's not against any state or people. Let me quote the words of the late Boris Nemtsov, the Russian politician killed a few years ago after the adoption of the original Magnitsky Act in the US. He said, "This is the most pro-Russian law passed in the United States in the history of our countries." We need Norway and other democratic countries to back up the rights of human rights defenders and whistleblowers by similar pro-Russian, pro-Azerbaijan, pro-Uzbekistan, and pro-people laws. Listening to Petter Eide, I do see that there are issues that we should discuss. But I also see that there might be a basis for a dialogue with you and hopefully then other members of parliament to seriously look into the issue of how sanctions eventually could be developed. It seems to be at least a willingness from your side to find a way to develop sanctions that could target the most serious violators that we are not able to reach at in any other way. Thank you.
Thank you. I think we just move on to Bård Larsen.
Thank you for this interesting conference. There is a lot of things to learn, and there are so many questions and maybe not that many answers. I think once again we have this conflict between idealism and realism when it comes to human rights and how to work against corrupt and authoritarian regimes. And in an ideal world, I think, first of all, I think it would be a good idea to implement this act, the Magnitsky Act in Norway. But in an ideal world, that would be, as you were saying, a global initiative, or it would be a European initiative. It would be somehow foolish to do it alone. And that would be the ideal solution, but it's not going to happen. It's not very likely. And then you are once again back to stage one, because if you can't have everybody working on it, nobody will do it, or some have. But I'm very uncertain. I don't think we should hold our breath that the Norwegian government would somehow, or the parliament would somehow go alone on this issue when we have the normalization of China, for instance, as one backdrop to this. So it all goes back to this conflict between realism and idealism. However, I think, as Ida was into here, I think that one important issue here is also the security issue, that this is not only a question about human rights, but also a question of security. And so I would strongly suggest that we implement this in Norway. But it is very frustrating when we talked about the United Nations and so on. It makes me think of the idea of League of Democracies. As Robert Kagan wrote a long piece about this several years ago, that we could also make some sort of arrangements between democracies, because it all comes down to, when you have a great idea of how to work politically, it boils down to a lot of nations doing nothing. Yes.
Okay, so just go on. I too want to congratulate, and I also want to thank you for the invitation to be part of this panel. And I'm very aware that we are discussing now towards the end how to deal and how to react and how to avoid and prevent violations that we're talking about. So, but I will try to give some perspectives based on my own work from treaty bodies, both the UN Committee Against Torture and also now as a member of the subcommittee against torture, to try to reflect on how the reprisal issue is dealt with in this context and see how things can be done, or hopefully can be done. But I just want to start, since we've been discussing a lot about corruption, I would like to refer to some discussions that we had some years ago in the Committee Against Torture, because questions were raised as to corruption with states presenting their reports. And the state parties would very often nod or look a bit surprised, and they would say, what does corruption have to do with torture? We have presented reports on torture. How can you come and you ask about corruption? But this, of course, was based on a number of reports, especially from civil society and human rights defenders, talking about experiences from places of detention and other places where every single service, every single act had to be paid for in order to be complied with. That includes, for instance, visits of families, has to be paid to the guards. And of course also up in the system, severe examples of how corruption is actually impeding the rights of persons and also being something that can explain and in some way accept that torture is happening. So in 2014, the subcommittee for the prevention of torture, in their annual report, had a whole chapter on corruption, stating, quite frankly, that the level of corruption very often coincided with high level of torture, and that fighting corruption is also a way of fighting torture. So this is something that has become an important discussion, and I think it suits well into the discussion we're having here today. In many ways, I think that how a state treats their human rights defenders is a litmus test of the democracy in the country. And we know, and we have been saying a number of times today, how human rights defenders, how civil society organizations and others represent very crucial participants in all work that has to do with human rights, the defense of human rights, both from monitoring on the ground to discussions in the conference rooms in international institutions or international bodies such as the UN. And in the UN, there have been measures taken. Gunnar and Peter Wille referred to the declaration 20 years ago with the establishment of the Special Rapporteur for Human Rights Defenders. And we know that there have been several declarations and resolutions lately now, a couple of days ago, in the General Assembly in order to defend the human rights defenders and civil society organizations working against human rights violations. But we must also include all the others that in different ways are collaborating with the UN mechanisms, and more focus has been given to that these last years, where one includes people who are collaborating, not necessarily defined as human rights defenders or being part of any organization, but who in many ways are either availing themselves or the mechanisms that are possible within the system, but also that are informing and collaborating in very different ways. And here I want to underline some groups that I think today are very important to look into also. That are those who are documenting torture, who are, for instance, health and health professionals. Personally, I'm visiting now as a member of the subcommittee a high number of prisons and places of detention, and one of the important issues that we're raising all the time is the fear of reprisals and how to deal with reprisals when people are invited to speak to us. That is people who are in prison, people who are in closed detention centers for migrants, etc. And of course, the risk of reprisals is very high. There are too many examples of risks or reprisals taking place. For this reason, by the way, the the treaty bodies altogether developed the so-called San Jose guidelines, which also specifies very clearly how to deal with reprisals against those collaborating with the treaty bodies. But just 2 words back to health professionals, because more and more you see that those who are engaged in the documentation and investigation of torture, both from the health and from the legal sense, are also provided or also threatened with reprisals. So the importance of strengthening different both state institutions and also associations in society, such as their own professional associations, is extremely important to work against this tendency and work against the risk that these people are facing in work with documentation. So I would say one of the perhaps most threatened person I met during the last couple of years was a doctor in a prison who was documenting ill treatment in prisons. The reports were read, which they should not be, and of course reprisals were back to the person involved. I want to end by just saying some words about what I see as main challenges that we have to work with. I think on all levels raise awareness about reprisals and threats against people who are collaborating and actively working in human rights. This has to be done on all levels, international and also in bilateral work. I think having this very clear on the agenda when one goes into both business and other forms of bilateral contact with countries is of high importance. I will not go into details about the other legal measures because I'm a psychologist, health worker, and will not at this point say other than the importance of developing legal protection for human rights defenders and also have the protection issue and the lack of protection as something very high up on the agenda in all international kinds of work. I also think that it's important that we are aware of the reactions of the situation of people who are reporting or who are working in the human rights context. Because those who are, I've often spoken to whistleblowers and to others who actually, after having said things and reported on things, and this goes true even for Norway, people feel alone, they feel excluded, they feel marginalized, and sometimes, of course, they're also in danger. So this is something we have to be aware of, that as part of our preventive work, we also have to protect and provide people with assistance so that the consequences of their brave work is not becoming too heavy on them and their family. Thank you.
Thank you. Being the last one on the list at the end of the day, most things have been said, but representing Amnesty International, I will especially speak from a human rights perspective, say a few words about the need to prosecute human rights violators and large-scale corruption, a few words about the challenges and risks, and finally a few words on how Norway can contribute to protect human rights defenders and whistleblowers. To us, of course, it's vital that perpetrators must be held accountable. First of all, to bring justice and remedy to the survivors and the relatives of the victims, a perspective that is too often left out. And corruption, as we all know, undermines development and the trust in the political system, judicial system, the economical system, and the trust in the public system as such. And history has shown us that the system based on impunity for human rights violations and corruption will become unstable and unpredictable. People's distrust, frustration, and anger will become social dynamite. And people will often, at the point, take to the streets. This could result in a change of the regime for better or for worse, lead to more repression. A repressive and corrupt regime is never sustainable, something corporate actors and investors should keep in mind. It's not enough for you just to be present in a repressive regime to make a positive contribution to human rights and democracy. You have to be a conscious corporate actor if you want to contribute to a positive change in any repressive regime. And when it comes to the challenges and risks, we see that too often public officials are directly or indirectly responsible for human rights violations and corruption. And they can do so because they are never held accountable. Whistleblowers and human rights defenders take a high risk in many countries, even with their lives at stake, when they dare to go public with the information they have, or when they dare to criticize the system. And we see that there's an increase in the number of human rights defenders and whistleblowers who dare to stand up against corruption and business-related human rights violations as targets. They stand up against very influential and powerful actors. Money is one of the strongest drives for human motivations to do good and to do bad. The organization, the human rights organization, Global Witness, document that more than 2,000 human rights defenders standing up against corruption and business-related human rights violations were killed in 2016. They pay a very high price for daring to stand up. But we also see that even in countries with large-scale corruptions, you will find honest and not at least very brave prosecutors. 3 weeks ago, Amnesty International organized a closed international expert meeting on the principles on corporate crimes. We had international experts, prosecutors for a number of countries that came together to discuss how we can use the corporate crime principles to promote a legislation in countries that makes it possible not only to investigate, but to hold violators when it comes to cooperation and corporate crimes accountable. And on this meeting, where the Nigerian state prosecutor, he faces threats almost every day. He's been exposed to at least 2 attacks on his lives, but he dares to stand up, just as a kind of positive remark that you have actors, even in these kind of regimes, who dares to stand up, and to show that it's not only human rights defenders like NGOs, journalists, trade unionists and so forth that's being targeted. Lawyers, prosecutors who really dare to try to hold these actors accountable are being targeted as well. And then finally, when it comes to what Norway can do, it's been referred to a number of times during the day to the resolutions, to the UN resolutions on human rights defenders. That's being initiated and promoted by Norway in the UN. And yes, on Monday, they managed to reach consensus on this last human rights defenders resolution. That is actually a great achievement. They stood up against very rough negotiations towards actors like precisely Russia, China, Egypt, Venezuela, Cuba, Turkey, trying to totally undermine the content of the text. But they managed to keep the text a strong one and to reach consensus. And really, all honor for that. That was a strong, strong fight. And I should, of course, add that Amnesty International and other NGOs made our contribution in lobbying our respective governments to stand up to support this resolution. And the resolution that was adopted last year had a special focus on human rights defenders standing up against corruption and business-related human rights violations, to secure that their rights are being protected and to stress the state's duty to protect them. And yes, it might be said that, well, states sign up to this, but does it have any value in practice? Yes, it does, because it gives me and any other actor who wants to a tool to challenge and to hold our respective governments accountable. We got to use it. If we do, it's much more than just words on a paper. It's a tool, And we had to, and we must use it. When it comes to what Norway can do then, yes, they've been, very strong on the international agenda to make sure we have these resolutions on human rights defenders. And our recommendation is that since Norway then have a very strong standing on this issue, they should refer to, and that includes not only the government, but every politicians in the Norwegian parliament, when you go abroad or if you have a state visit, you should always refer to and promote the content of this resolution in all your multilateral and your bilateral meetings where you meet government actors, public officials, representatives of the Office of the Prosecutor or corporate actors to discuss human rights, international justice, business or developments. That's your responsibility, Petter Eide and all other Norwegian politicians being elected by us, the people. And of course, human rights organizations like Amnesty International and the other present here will continue to fight impunity and to make sure that no one is above the law. Thank you.
Thank you. Some very good suggestions there. I think Björn, you wanted to comment on something in the...
Yeah, if that's okay.
Yes,
Yeah,
it is. But then, yes, please do that. But then I would follow up with a question on back to the Magnitsky legislation and the point that Petter made on the very name of this kind of legislation. Is that the problem? Is that what's in the way for Norway to adopt such measures? Or is it other things? Maybe you also wish to comment on that.
Yeah, I can do that. I mean, very much doubt that the change of name would lead to a different Russian approach. The whole starting point for this proposal is the fact that Russia today is not acting towards its human rights defenders as they should. They are not giving them protection. They are not bringing the perpetrators to court. On the contrary, they are protecting the perpetrators. And this is why we have started the whole process. In this room, at the moment, I guess there are between 40 and 50 human rights activists from abroad. People we have invited for this conference and for this week's celebration of our 40th anniversary. Many of them are doing their work in societies where they are in danger due to their work. We would like to see them protected in a better way, and we believe the threat of sanctions could increase that level of protection. That's, in a way, the essence. I really don't think the change of name would lead to any increased protection in Russia. That's one point. Secondly, just a very short comment to you, to Bård Larsen, concerning your thinking of idealism versus realism. I guess as a human rights activist, as a human rights person, we are idealists. We do believe in bringing up the vision, trying to define it, and then, of course, do our concrete work in order to achieve it. Just an example or two examples. I do remember the 90s in the Balkans when it was suggested that you should establish an international tribunal for the former Yugoslavia. Quite many people, I guess most people, believed that was impossible. It was not realistic. It was not something that could be done. It was done. Later on, you had exactly the same kind of resistance, unbelief in the idea of establishing an international criminal court. And we got it. Our challenge today is to improve the work of the court, but at least we have got it there. Third and last point, I'm very happy that Petter is here. In fact, he's the only politician that we reached out to that accepted the invitation. And for me, this is a bit puzzling. Why is it so difficult for us to get into a dialogue, a real dialogue, with the Norwegian politicians? I'm not sure about the answer, but hopefully the fact that you are here, the fact that we have this conference highlighting the issue could lead to improved dialogue with the political part of Norway, and hopefully something to happen here too.
Thank you.
In the future. Thanks.
Unfortunately, time is flying so quickly, and I think we really would like to also hear from the audience one or two questions, and I think, unfortunately, that's all we got in terms of time. So,
Я Любовь Волкова, я член группы независимого расследования гибели Магнитского в СИЗО «Матросская тишина». Вот, я очень благодарна Норвежскому Хельсинскому комитету за организацию этих слушаний, потому что они начали новый этап в защите прав человека, призывая международную солидарность, развивая ее. Вот на эту международную солидарность мы и рассчитываем, и я поэтому попросила слова, потому что мы сейчас очень нуждаемся в международной солидарности. Нас в России, правозащитников, постигла большая беда. И об этой беде, вот даже в резолюции, которая позавчера появилась, ничего не сказано. Это говорит о том, что мы не донесли до мировой общественности то, что произошло после того, как было расследовано дело Магнитского в российской тюрьме. После того, как мы расследовали это дело, а мы ведь сделали самый первый, самый важный шаг, который никто не может здесь опровергнуть. Никто. Мы зашли в камеры, куда ни мама, ни папа, ни юрист, ни следователь, ни адвокат не может зайти. А мы имеем такой мандат, который позволил нам пройти по всем этим камерам и быть независимыми свидетелями. Мы независимые свидетели. Сейчас нас называют расследователями. Да, расследователи. Вот наша эта группа – это расследователи. И я вам хочу сказать, что конкретно каждого из нас не коснулось вот то, что нас посадили в тюрьму. Ни один волос не упал с моей головы и с головы членов нашей группы, наших 6 человек, которые возглавляет мужчина Брynjulf Валерий Васильевич, и 5 женщин нас пошли в эти камеры бороться с системой коррупции и убийств в тюрьме. Но дело в том, что самое страшное, что нам сделали, нас лишили возможности выполнять свой гражданский долг, делать свое дело, проводить независимые расследования в тюрьмах при нарушении прав человека и при гибели людей. Конечно, Валерий Васильевич Брynjulf пострадал. Он попал в стоп-лист в СМИ. Его аппарат президента вычищает из всех предложений. Он должен был быть в Совете по правам человека при президенте. Председатель Совета несколько раз выдвигал его кандидатуру. Там она зачеркивалась. Это все связано с расследованием дела Магнитского. Потому что это была отправная точка по преследованию правозащитников в России. Теперь, прошедшие 8 лет, мало того, что мы не попали все в общественно-наблюдательные комиссии и лишены этого права, такого права лишены по всем регионам России. Ведь по закону об общественном контроле вот такой мандат, который позволяет входить в каждую камеру и расследовать, что там произошло, получили более 80 комиссий. И там обязательно, как говорится, не стоит село без праведника. Обязательно находились люди, которые расследовали причины бунтов, вот, например, как Щуры из Челябинской области, которые вот вам известны. Вот. Они это делали расследования, публиковали, доносили до общественности. Теперь их всех вычистили. В Челябинской, Свердловской области, в Магадане, в Сахалине. Их всех лишили возможности. То есть были составлены списки, по которым работала общественная палата, исключая нас и наши заявления, которые мы подали для того, чтобы работать. Зоя Светова подавала, она хотела работать в лагерях Мордовии. Ее туда не допустили. Меня не допустили. Но не допустили всех, кто мог бы проводить эти расследования. То есть всех расследователей. Поэтому мне бы очень хотелось, чтобы Норвегия, как часть вот мирового сообщества, которая хоть она конкретная страна, но есть там люди, которые входят в международные структуры. Вот Нора, которая является членом подкомитета по попыткам при Организации Объединенных Наций. Вот. Я думаю, что у каждого из вас какая-то есть возможность поднять голос в защиту самой системы общественного контроля в России, юстиции, которая сейчас разрушена. Она просто ликвидирована. Несколько статей в «Новой газете» говорили о ликвидации контроля, но ни радио, ни телевидение, ни другие СМИ эту тему не поддержали. Она закрыта в России. Мы, вот 3 человека, я, Лена Масюк из «Новой газеты» и еще одна член нашей группы Дубикова, мы подали в суд на Общественную палату. Ну, нетрудно догадаться, что суд этот нас не поддержал. Суд просто-напросто нас презирает. Даже нашу попытку поднять ногу на Общественную палату. Вот. И сделали мы такой доклад небольшой. И один из профессоров, или я не знаю, он работает в университете Осло, Гайер, он перевел даже наше обращение. И мы это обращение отправили президенту, отправили в Общественную палату, отправили во все структуры, которые могли. Ни президент, никто нам ничего не ответил, только ответила Общественная палата. Радостно, коротко и ясно. Вот мы сделали новые комиссии общественные, в которых вас нет. И очень хорошо они теперь работают. Теперь тишина и гладь. Если мы сейчас не обратимся к вам за помощью и не получим ее, то никогда никто из вас не узнает, что происходит в наших российских тюрьмах и полиции. Никогда. Все это ликвидировано. Спасибо.
Would you, Nora, like to comment on that?
I think it's there's so much to be said about what you said, and of course having the possibility really to look into what's happening on the ground, both with national and international bodies, and be able to do that would be a great thing. The first thing that has to be done, since you asked me directly, Russia has not ratified the optional protocol to the Convention Against Torture, so they present their reports in the Committee Against Torture, but they are not, unfortunately, yet a state party to the optional protocol, which is very sad because I know that you have a mechanism in place that could be able to do this kind of work. So we will be in contact the day that happens, but what you're saying is much more general than that, so that's something that I think goes for everybody in this room to do something and to look into what's actually happening. So thank you very much for sharing these extremely important observations.
Thank you. Unfortunately, time was up, but we allow for one last quick question. And I think you were quick to identify who that was first there. We can't really see.
No?
Yeah. Okay.
Thank
Please,
you,
sir.
Mr. Chairman. My name is Ivar Amundsen. I am in human rights, and I have my friends in the opposition in Russia. I have a message from you from the representative of the Council of Europe, Andreas Gross. The audience will remember that this morning his name was mentioned, and Andrei Nekrasov made a claim that he had categorically stated that he was absolutely convinced that Sergei Magnitsky was not murdered. I know Andreas Gross, and I couldn't believe that. So I called him, and he just called me back, and I put the question to him, is it a fact that you have said such a thing? And he said, absolutely no. To the contrary, I have said and I have written so many times that I am absolutely convinced that Sergei Magnitsky was murdered. And Andrei Nekrasov knows it. He also asked me to add...
I think we have to just... You think you made your statement, and I think we have to move on.
Okay,
thank you.
Right.
So...
Yes, okay. Well, I think we need to finalize this panel. Thank you so much for your contribution, and then we'll have a last round of summaries later concluding remarks.
We have now come to the end of the fourth panel. We will thank this panel very much, and we will have as a last part of this seminar some concluding remarks. And this will be done by Mr. Åge Borchgrevink and the chairing panel, and also Gunnar Ekelöv-Slydal. So will be a change of panel here now. Okay, we are then ready for some concluding remarks. And this seminar, this event, has a rapporteur.
Yes.
And the rapporteur is Mr. Åge Borchgrevink of the Norwegian Helsinki Committee. And I'll leave the word to you to sum up this. It's a challenging task, I would say, but we are very curious to listen to what you have to say.
Thank you, Frode. Yes, hello, my name is Åge Borchgrevink. I'm a senior advisor in the Norwegian Helsinki Committee. And I've given 5 hours to, no, I'm 5 minutes, I guess it was. So, yes, it's a challenging task. I was reminded of this Monty Python sketch, you know, summarize Proust competition. So, yes, I've of course listened with great interest to all the presentations today, and I was trying to discern a plot. Is there a plot in this quite sprawling affair? We had 3 different panels, 4 actually. Yeah, and then a number of individual presentations. So, but I guess just to do it briefly, the tone was set by Bill Browder when he described, he found out that his lawyer was dead. We start with the crime. And the first panel was devoted to the facts of this crime. And we had a number of really interesting presentations, I think. For instance, from Valery Brynjulf, who described in detail the maltreatment and circumstances around Sergei Magnitsky's death. And Vadim Kleiner, who also was able to substantiate a lot of the story presented by Browder with the concrete documentation. However, there was also a counter-narrative and a very, I would have to say, brave performance by Andrei Nekrasov, who questioned just about everything about the accounts of Kleiner and Browder and Brynjulf and basically everybody else. I guess his main contention, or the most substantive of what he said, was that the companies purportedly stolen by criminals and policemen may still have been within control of Hermitage Company and Bill Browder. But I guess I didn't see kind of, yes, it is a plausible theory, of course it's a possible theory, there are many possible theories. I guess I did not see so much evidence from Nekrasov. I think that he was maybe given a too short time and he pointed to his movie, but yes. So confronted then with this this crime, the situation of the dead lawyer, it seemed that this attack on an individual whistleblower was something that resonated. I mean, that had this was a description of a greater problem. And to cut it short, I think that Gunnar kind of described this within the framework of a larger oligarchic system. As you can say, not only in Russia but in many other places. Mr. Papashvili presented on Azerbaijan, which is a petrocracy, you could say, a tightly controlled money, a tightly controlled regime. So, and Gunnar also pointed out that we lack instruments to face up to this challenge that is presented by this oligarchic system, where you have economic crimes followed up by human rights violations, ending up in money laundering that also includes Norway and other Western countries. So how do you deal with that? I guess that was the main issue. And then you had, I guess, 2 basic schools among the presenters. Some pointed to the existing institutions, specifically to the UN, and made a point about the recent resolution in support of human rights defenders. Another school maybe was not happy with the current status of the institutions. So, for instance, Mr. Papuashvili, he described the case of Ilgar Mamedov, who after 2 victories in the Court of Human Rights is still in prison, so that remedies are exhausted. Now what? And that was, of course, also Bill Browder's point in the beginning, you know, take this to the next step. And the Magnitsky sanctions is then presented as a next step that will try to individualize responsibility and go after the perpetrators. But with legal safeguards, with the possibility of judicial review safeguards that would ensure that not just anybody ends up on a list and are sanctioned. Yes, so we had then the description from the US Embassy of how the Magnitsky Act and the Global Magnitsky Act, how they work in the United States, and it was also mentioned that a number of other countries have adopted legislation, similar type legislation. So I guess from the start, the main question for us was what can Norway do, and wouldn't it be good to have Magnitsky sanctions here too? And Beate said also, what can Norway do? I guess the general notion here was that more was the answer. Yes, Norway can do more. But Bjørn pointed out the fact that only one parliamentarian was willing to take part in this hearing, and that goes back to what Bård said, that this is a security issue, not only a human rights issue. And well, draw your own conclusions. The parliamentarian who was here was not even happy about sanctions. And also the director of the national institution did not want to discuss sanctions. So it seems that Norwegian Helsinki Committee has a little bit of an uphill if it wants to push the rock up the hill. Yes, there was one quote that I just had to take down, and I will end on that, and that was representative of Open Russia, who said that balls are rare, especially with regard to Russia. Yes, so I leave it at that.
Okay, thank you very much. From the chairing panel, I will see a few words first, and then my colleagues will consider whether they want to add something. I start by saying that we came here to learn and explore, and I think we learned a lot about facts and conflict, and also learned a lot about how to chair conferences. So, which was so we on many levels we have learned a lot, and on that note, I just have to apologize that not everyone was available to ask the questions that they wanted to ask, and also that the time was a limit to us. Of course, there are lots of these issues that deserved even more thorough discussion than we had. But nevertheless, we have had interesting discussions, I think, and we have heard a lot of interesting views and opinions from the panels. We are not here to render judgment, so I will not pass judgment on the Magnitsky case or anything else. But I think it is puzzling that this case is possibly one of the most well documented in a way. But it's disputed, and there's different views. And even then, it is hard to get this thing settled, which gives me, or that's a lesson to learn, that there's a need for stronger systems, for stronger mechanisms to decide and to put things to rest and say, but this is how it is. And that possibly, my general experience is that that has to be done on the domestic level. It's very hard, even your optimistic view on the war tribunals. I think it's hard to foresee that there will be a sanction tribunal that can, in a short term, be established to do these things. I think it must be done on the domestic level. So that is one lesson to be learned. But then also, I mean, what we need to appreciate is also, of course, that there's lots of problems. Politicians face a lot of problems. Those who try to implement them face a lot of problems. But those who really face problems are the human rights defenders. So we need to do what has to be done. And my hope is that this conference has put the Magnitsky case on the agenda in Norway. More people than before know a lot about the case, about the issues that it represents, and the challenges both in that case and in the general problem of the persecution of human rights defenders has to be taken seriously. And I think Norway has to take a close look at the policy of just following US Security Council-backed or EU-backed sanctions and look how to do this more efficiently. And I hope this seminar has contributed to that discussion. Thank you. Brynjulf, do you want to add something?
Maybe just a short comment. It's sort of absurd during this seminar that it seems like there's not only humans who seek the rule of law, but also money seek the rule of law. And it looks like if rich people in countries where there is no rule of law, they will seek to sort of outsource the rule of law and keep the money and use the money in places where there are rule of law. So from that perspective, the Magnitsky approach seemed very effective because it hits right on the target where people are most vulnerable. On the other hand, we see a lot of problems. I mean, like Pavel Chikov said, that there are a lot of problematic things with it, and it might in the short term even make the situation worse for human rights workers, for example, in Russia. And one can easily see that it hinders political dialogue, which probably explains the lack of enthusiasm from Norwegian politicians. So there are still a lot of issues to be covered in this area. Thank you.
Yeah, let me just add that I think this has been a very interesting day. I think it also has demonstrated very clearly that the fight against corruption and the protection of human rights actually goes together. And I think there have been many demonstrations and examples of that, and which also means that we have to continue to work together on these issues. And and then I also hope that Norwegian politicians start to engage in this across the political parties. And so I think we just need to continue to hammer some of these issues.
Thank you.
Final remark.
Not, at least not yet, because Gunnar Eklöf is the one who is supposed to have the last word, and I think we'll stick to that actually.
Yeah, to be fair, I just want to say a very few things and very shortly. As a human being, I'm guilty of many things. But in this context, I'm in particular guilty of three things. We invited a Canadian MP, which was very much involved in the debate and the adoption of the Canadian Global Magnitsky Act. And he initially accepted to come here. He was very happy, but then something came up and he couldn't come. And then he sent us a video with a message to you. And you will not hear that message today. So I'm guilty of that. We will put a link on our website to that message. I think it's very interesting because Canada made a very thorough assessment, both of what sanctions can do and what they cannot do, and the pros and cons of Magnitsky sanctions. And they ended up with, by consensus, it's an easier word to say, adopting a Magnitsky Act. So that's my first guilt. The second guilt is that I did not buy a bottle of wine to the members of the chairing committees, or not even flowers. But I want to thank you very much for being such... Exactly. So it's in the spirit of non-corruption. Yeah. But wholeheartedly, thank you very much. I think you did a very fine work. It was not easy all the time, but it was very good to have you there as a kind of anchor for the whole event. Thank you very much. I am also guilty of putting together a very dense program. So many of you could not say what you wish to say. My appeal to you is to forgive me, of course. And secondly, you can say what you didn't manage to say here today in other contexts. Because the main thing about an event like this is that it should inspire you to work continuously on the concerns and the viewpoints that you think are important. So forgive me and say what you have to say in the future, in other contexts. And then I have to thank all of you for showing such a stamina, staying for a long day. If you happen to say something and you regret, I'm sorry, because we have all on tape. We did not permit others to record the hearing. I'm not sure it has been respected 100%, but we decided to record the hearing, and we will use some of it, not misuse or abuse it, but for the good cause. I have a special challenge to Mr. Petter Eide. You were very courageous to come to us today as the only MP. I have a confession to say there too. We didn't invite all MPs, so some others could have said yes. But at least we invited a few, and you said yes right away. I will challenge you to help us to organize a meeting in the Parliament with parliamentarians from whole political specters, so that we can discuss and be very precise of what we are thinking about. Because there are some misunderstandings about what Magnitsky sanctions is. And there might be other good ideas. Because what we heard from almost everybody here, maybe everybody, that there is a big problem. And we have to do better to be part of the solution. So that is a challenge to you as a politicians. I'm a newly elected member of the parliament, but there is actually a tradition of MPs in Norway being engaged in the Magnitsky case. So it's not true that they are totally neglective of this. There has been letters to the government about the need for Magnitsky sanctions from at least 4 of the parties which are in the Norwegian parliament. I also want to thank those who have recorded this event for us, Caroline and Emmanuel. Of course, I should not thank you wholeheartedly before I see the result, but I hope it's good. And then there are 2 crucial persons sitting in a box there, our interpreters. Then I also want to thank the team in the Helsinki Committee who helped this, in particular Anna, but there are others also who worked very hard. And as you know, this is not the end of the story. There will be some light refreshments, and then there will be a very interesting theater play called 1 hour and 18 minutes. And I don't want to tell you why that play has exactly that title. You have to watch it to understand it. And that starts at 5:30. So in 30 minutes, it means that you have to refresh yourself and be back in 30 minutes. Thank you all.